Prime Minister, the Honorable Chief Justice of Uganda, the Deputy Chief Justice of Uganda, the Honorable Ministers present, the Principal Judge, Justices and Judges, Members of Parliament that may be present, Heads of Diplomatic Missions, Religious Leaders, Chairpersons of Constitutional Commissions, Heads of Jealous Institutions, the Head of Public Service and the Secretary to Cabinet, if present, Permanent Secretaries present, the Chief Registrar, the Inspector General of Police, the Commissioner General of Prisons, Your Worships, Registrars and Magistrates, the Solicitor General, the President, Uganda Law Society, Senior Counsel present, legal practitioners, invited guests, ladies and gentlemen. Good morning, Happy New Year and Happy New Law Year. It's with deep honor and humility that I stand before you as we convene to open the new law year 2025. Allow me to congratulate all stakeholders in the justice system for their tireless commitment to ensuring that the administration of justice remains a cornerstone of our democratic governance in Uganda. Reflection on the rule of law and constitutional imperatives. Our gathering today reflects the fundamental principle of constitutionalism, the separation of powers, where each arm of government operates within its defined boundaries while maintaining a harmonious collaboration. This constitutional order, enshrined under Article 126 and 128 of our Constitution, is the bedrock of the judiciary and guarantees its independence. The judiciary, in its role as the guardian of justice, has the power to ensure protection of human rights and preservation of legal certainty. It is through judicial adherence to doctrines such as stare decisis that consistency and predictability in the interpretation of laws are maintained. As we deliberate on our progress and challenges, we reaffirm our unwavering commitment to procedural fairness, equity, and access to justice for all. Achievements and legislative developments. In the year 2024, we saw a significant legislative and policy reform. We saw significant and legislative policy reforms aimed at modernizing our justice system, notably the launch of the 7th revised edition of the Principal Laws of Uganda, which can be accessed online. We are also working on the Uganda Law Reform Commission to ensure that the amendments passed are incorporated. In the online version to ensure easy access. A lot of effort is also going into the preparation of the revised edition of the subsidiary legislation. The following are bills passed into law by the Parliament of Uganda. The National Commission for UNESCO Amendment Act 2024, the Children Amendment Act 2024, the Civil Aviation Authority Amendment 2024, the Excise Duty Amendment 2024, the Income Tax Amendment 2024, the Higher Education Students Financing Amendment 2024, the National Council for Older Persons Amendment 2024, the Uganda Road Fund Amendment 2024, the National Roads Authority Repeal Act 2024, the Arbitration and Conciliation Amendment Act 2024, the National Information Technology Authority Uganda Amendment Act 2024, the Dairy Industry Amendment Act 2024, the National Agricultural Advisory Services Amendment Act 2024, the National Coffee Amendment 2024, the Cotton Development Amendment Act 2024. These legislative measures reflect government's responsiveness to contemporary challenges while upholding the rule of law. Attorney General versus Michael Kabaziguruka, Supreme Court Civil Appeal number 2 of 2021. The Supreme Court of the Republic of Uganda, sitting in appeal of the decision of the Constitutional Court, petition number 45 of 2016, Michael Kabaziguruka versus Attorney General, delivered its judgment on the 31st of January 2025, where it inter alia found that civilians cannot be tried in the General Court Martial because of the way the court is constituted. This is a landmark decision, and the government undertakes to abide by its outcome. The judgment of the court came with several recommendations for reform of the UPDF Act. Government is studying the recommendations of the court and will soon table a bill in Parliament with appropriate reforms and amendment to the UPDF Act. Lastly, government has introduced the Land Information System, where certificates of title are issued through a digital system, and searches on the same can be done online in real time. The general public, lawyers, and judicial officers are now in a position to know the registered proprietors and any encumbrances and make decisions with appropriate information known to all concerned. Judicial independence and public trust. Judicial independence, as guaranteed under Article 128 of our Constitution, is sacrosanct. The executive remains committed to non-interference in the judiciary, in judicial affairs, and recognizes that the strength of our democracy is measured by the judiciary's ability to dispense its and recognizes that the strength of our democracy is measured by the judiciary's ability to dispense justice impartially. However, independence comes with accountability. It is imperative that judicial officers uphold the highest ethical standards, ensuring that their conduct and decisions inspire public trust. Recent landmark rulings on constitutional rights have demonstrated the judiciary's capacity to navigate complex legal questions with both rigor and integrity. Strategic priorities for 2025. As we commence the new law year, I highlight the following strategic priorities that require collective effort. 1. Access to justice and case backlog reduction. The persistent backlog of cases remains a barrier to timely justice. My office will continue to support the operationalization of specialized courts, including the Land, Anti-Corruption, and Family Divisions. Digital transformation. The judiciary's e-justice initiatives, including electronic court case management information system and virtual hearings, are vital to improving efficiency. However, we must address emerging pitfalls in the infrastructure and digital digital literacy to explore rolling it out countrywide to all the other courts, enhancing legal education and ethics. I commend the Uganda Law Society and the Law Council for their commitment to enforcing compliance in continuing legal education, CLE, requirements and upholding professional ethics. However, I urge my fellow legal practitioners to proactively pursue training in emerging fields that present novel legal challenges within our justice system, such as artificial intelligence, construction law, natural resources, and energy law, and others. Legal education and professional ethics are at the foundation of public confidence in the legal profession. Human rights and protection of vulnerable groups. We will continue to strengthen the implementation of laws protecting children, women, and people with disabilities. This aligns with our obligations under both domestic statutes and international conventions, such as the African Charter for Human and People's Rights. Challenges. Most of the complaints we continue to receive in the Law Council against lawyers in private practice are usually from elderly clients, and the complaint is that lawyers have failed to account for funds received from clients by poor or non-representation in court. Funds from court awards paid in the accounts of lawyers do not often reach the clients. Please, this should stop. Secondly, I wish to note with deep concern a deterioration in the collegiality between members of the bar and respect for the bench. We have instances where members of the bar openly attack judicial officers. I appeal to all members of the bar to exercise a level of professionalism amongst themselves and when dealing with the bench. A call to action. Ladies and gentlemen, as officers of the law, we bear a solemn duty to safeguard the integrity of our legal system. Let us rise to the challenges of our time with courage and resolve. Let us defend the Constitution and the rights it guarantees, uphold the doctrine of separation of powers, and be torchbearers of justice and equity. To my colleagues at the bar, I remind you that the privilege of legal practice comes with profound responsibility. We must exhibit professionalism, courtesy, and respect for both the courts and our clients. Ethical breaches erode not only our reputation, but also the fabric of the rule of law. In conclusion, I echo the timeless words of the former United Nations Secretary General Kofi Annan. The rule of law is not a privilege for the few, but the foundation of society. It is the protector of rights, the enabler of progress, and the defender of justice. Let the new lawyer inspire us to strive for justice, for a justice system that is accessible and efficient and anchored in the principles of fairness and equality. May our collective efforts strengthen Uganda's legal framework and fortify the trust of our citizens in the administration of justice. I wish you all a prosperous and fruitful new law year for God and my country.
Thank you very much, the learned Honorable Deputy Attorney General. Let us give him a round of applause. He's given us words to take to heart and for introspection as judicial officers and the advocates and all of us here. Thank you very much. Our chief guest, I'll just recognize a few more people and we proceed to the next remark. We have their excellencies, the ambassadors who are here with us. And from the German, we have the German ambassador with us. His Excellency Matthias is here with us. You're most welcome. The head of the Austrian embassy, Her Excellency Dr. Katia, a long-term friend of the judiciary. From the Swedish embassy, we have the Swedish ambassador with us, Her Excellency Maria. You're very most welcome. And from the Kenya High Commission, we have the Deputy Head of Mission, Ambassador Dr. Suleiman. You're very, very most welcome. From the Belgian Embassy, we have Miss Stephanie Melis. You're very most welcome. And lastly, from Netherlands is the Mr. Ode de Jong. You're most welcome. There is also a senior counsel, Fiona Wall. That is my classmate, and you're very most welcome. We now proceed to listen in from the Honorable Minister of Justice and Constitutional Affairs. Thereafter, we'll have an interlude and then have an address by the Honorable the Chief Justice. Honorable Minister, you're welcome.
Our Chief Guest, the Honorable the Chief Justice of Uganda and the Honorable the Deputy Chief Justice, permit me to stand on the already established protocol. We want to thank you, my Lord the Chief Justice, for always inviting us to be part of this. For me, sitting at the Ministry of Justice, it gives us an opportunity to come and bask in the achievements of the judiciary. I also do believe that it is a manifestation of working together. Your values are clear and they are written everywhere around us. Independence, impartiality, transparency, professionalism, integrity, accountability, equality. You would call these your 7 commandments. Now, like all the commandments, you don't need to break all in order to go to hell. It is enough to break one. So you cannot say, I'm professional, but sometimes I'm influenced by money. That I'm actually impartial, but I can succumb to undue influence. So today, we congratulate you, my Lord the Chief Justice, and the team you lead, for the transformational work you have done. It will be up to our chief guest to speak for the government. But as your mouthpiece in the government, because you don't sit in parliament, you don't sit in the cabinet, it is the Minister of Justice who, despite occasionally criticizing the judiciary, largely has the duty to represent the interests of the judiciary, because the judiciary serves the people of Uganda. We congratulate you for the teamwork that we see in the judiciary. Surely, this kind of alignment is important. We also thank you for doing your part to ensure that the constitutional spirit of checks and balances are manifest. Though we call them checks and balances, they are actually two separate concepts. Most people think checks and balances mean one thing. The checks are supposed to limit power, and occasionally you draw the line when we cross it as the executive. And each of the other branches also check the other. The balances means that you cater for the broad interests of all Ugandans. So we thank you for that spirit. On Monday, our chief guest on the order paper will be the National Alternative Dispute Resolution Policy. Many people think these cases are about the lawyers and the judges. These cases are actually about the parties in dispute. You'd think that it is common sense, but somehow the way people talk, it is as if the courts also are disputing. Like the recent case, it's the government through the Attorney General which was disagreeing with Mr. Kabazigiruka. The judges were not involved. They never filed the case themselves. They only got involved because we were not agreeing about what the law is. Whether it is about property, whether it is about money, whether it is about land, whether it is about civil liberties, the disagreements are among the citizens of Uganda. But most of the time, we talk as if the judiciary is part of the conflicts. So the ADR policy will support the initiative you, my Lord, the Chief Justice, and the judiciary are already doing. For instance, plea bargaining. When you read the media, they talk as if the accused persons plead guilty at gunpoint. I don't know whether any accused person pleads guilty at gunpoint. If so, that would be very unfortunate. The truth is, nobody wants to plead guilty. In one of the interesting English cases, somebody was taken to court on accusation of stealing a sheep. And the counsel for the defense, as all lawyers try to plead very vigilantly for their clients, claimed that the sheep whose bones were found in the defendant's compound had fatally injured itself by rubbing its neck on a sharp rock. So, this is what the judge said. I found this case very interesting and I put it somewhere in my notes. The judge said, that is a very plausible suggestion to start with. But having commenced your line of defense on that ground, you must continue with it and carry it to the finish. And to do this, you must show that not only did this sheep commit suicide, but that it skinned itself and then buried its body, or what was left of it, after giving a portion to the prisoner to eat in the prisoner's garden and covered itself up in its own grave. I don't say the jury may not believe you, we shall see. But gentlemen, what do you say? Is the sheep or the prisoner guilty? These are the interesting scenes we see in the criminal division. Even somebody who shouldn't waste court's time will really insist that they are not guilty. And we, the lawyers, obviously are very creative in trying to seek all avenues. So the judiciary our chief guest has found a way to say, look, instead of going to jail for 5 years, you can actually get 2. Instead of going to jail for 2 years, you may be asked to do community service. You remember the famous case of KCCA where the late Honorable Abiriga went and relieved himself on the newly painted walls of, I think, the audit department. So he was arrested under the KCCA rules. He pleaded, of course. He said, you know, I'm diabetic and sometimes I cannot hold my bladder. So the court was lenient and they gave him a sentence of a fine. But if he had insisted, things would have been worse. This, in my view, is the way to empty the prisons. Luzira is overcrowded. We have 4 times the people we should be keeping there. Before coming here, I had a conversation with the Minister of Internal Affairs. And he told me that he hopes to persuade government to actually relocate Luzira prison so that we have a bigger facility on larger land. He even told me something scary, which I hope the inmates will not get to know, that the walls are actually not strong enough. So if you have a knife and you have a lot of time, you can easily scratch your way in the course of 1 year to freedom. Definitely, this is worrying. Through the government policy of rationalization, the Center for Alternative Dispute Resolution is now coming to the Ministry of Justice as a department. I've asked the Attorney General to make sure that we recruit someone at the rank of a commissioner so that those who are involved in arbitration and mediation actually have the requisite skills. Parliament has already reallocated the funds that had been budgeted for those rationalized agencies to go to the line ministries. We also hope to make some changes in the law to increase the jurisdiction of chief magistrates and other magistrates' courts. You find high court judges stuck with all sorts of cases which should actually be handled by chief magistrates. And these developments are positive, and the judiciary is already leading the way in this. I wish to call for more mentorship of our judicial officers. Our schools of law do not teach character. They give you a lot of knowledge. You will be very clever and very good in your profession. But things like character are a result of mentorship. I've had conversations with the leadership of the Uganda Judicial Officers Association, and we hope that through mentorship, now that we are recruiting very many new judicial officers, it is important that the senior judicial officers start mentoring the new people who are coming. His Grace the Archbishop will correct me, but I'm told that the origin of the staff you carry is that when you have a stubborn ship, you can disable it a bit, you break one leg so that it slows down, but then you as the shepherd, you now have to carry that ship on your shoulder. So the ship gets very close to you, it gets to understand your voice, even your smell, and goes wherever you go. Of course, the ship will heal, but when it goes, it may actually be probably the best ship ever, almost like St. Peter, because St. Peter was not as straightforward as you remember in the Bible. The passages, as I always say, are there between the book of Genesis and Revelations. You will find it. It is there, I'm sure, between those two books. So, Peter, after betraying Jesus, he went to warm himself by the fire, and he continued denying, he didn't want to be associated with his master. But also he had been disappointed, because for him he was looking at things through worldly lenses. Even when he pulled out his knife and cut off somebody's ear, thinking that he would get a medal from the master for courage. Instead, the master put back the ear, and he must have been very disappointed. What sort of war is this, where now you heal the enemy instead of killing them? But eventually, he is the one who is said to have been the rock. So, some of the errant judicial officers that are subject to disciplinary proceedings eventually may actually be the very best if we adopt this system of mentorship. I'll speak about myself. I was not an easy student, to put it mildly. All through my journey, I have some classmates here in the judiciary. They know what sort of person I was, even at the university. In primary school, I was always put in front, and the headmaster always called me to his office. I thought he liked me, but actually the fact is that he thought I was difficult and I needed special attention. So some of you young judicial officers, when you see the Chief Justice is always calling you and talking to you, it may actually be a signal that you need some will alignment. Which is not a bad thing, because it means that the senior people have faith in you. I'm just giving you my own example in line of the shepherd and the shepherd's staff. This is important even for members of the bench. Members of the bench also, we hope you can really focus on the substance of these cases. Preliminary objections, interlocutory applications, injunction, this kind of application. So judges are all the time spending all their time dealing with your applications instead of the substance of the case. I hope there will be a solution to that. Of course, we the lawyers, sometimes we want to earn our money, so we must show everything to our client. I'll tell you my own story. In the early days as a young lawyer, in LDC during moot, you are taught how to be militant in court to really show your client that you're a fighter. So one day there was a case involving a client of mine who had been accused of threatening violence, and he is alleged to have chased his wife with a panga. So as a young lawyer in my 20s, I started cross-examining the complainant, or rather examining her crossly, really. I don't think it was cross-examination. I asked her, so what time was this incident? She said it was around 7 p.m. So it was dark. Yes. And then, as usual with young lawyers, I put it to you that you are a liar, because there is no way you would have seen any panga. And then the lady rubbishes me by saying to the judge, my lord, it is the lawyer who is a liar because he wasn't there. So this mentorship is not only about the judges, it is also about the lawyers. I urge the president of the Uganda Law Society to ensure that the troops that he leads are focused on the proper approaches to serve the clients better. Like this case which has just been disposed of. These big lawyers with big names have not even extracted an order to serve on anybody. I asked the Deputy Commissioner General of Prisons, have you been served with any order? No, I haven't. Instead, there's a lot of politicking about it. I don't know, maybe the affected people should consider changing lawyers who are focused on getting them freedom rather than political capital for themselves. Because now we have hybrid lawyers. They are in politics, they are also in legal practice. So you do not know whether they are now running on the normal fossil fuel or hydrogen at any given time. This I have to say very plainly, because if I'm a lawyer, I'll first get my client out, then do the politics. And indeed, the liberty of citizens is paramount, and we urge the judiciary as much as possible to always make cases that do with the liberty of citizens a priority. So, for instance, if there's a bail application, it should be heard first. Every other thing should be put aside to make way to handle the question of a citizen's liberty. I congratulate those who are promoted, and I understand it was God's work, but on earth God works through human beings. The Judicial Service Commission, who did all the interviews, the president, who has to make the difficult decision of out of the long list to make the appointments, and then the candidates who stepped forward. The judiciary is now very attractive, our guest of honor. The pay is very good. During the celebration of the Uganda Judicial Officers Association, I arrived late, and I cracked a joke that I had been busy trying to prepare my CV and application for the post of Deputy Chief Justice, which of course was a joke. The post has now been taken. So I call for the government to support the judiciary even more. Our guest of honor, in order to support the work of the Uganda Judicial Officers Association, I made a pledge yesterday. This is the Uganda Judicial Officers Association. They need a van to move up country. Our chief guests, some of our judicial officers at the rank of magistrates, are small gods in their jurisdictions. They wield power. I understand one time somebody was jailed for coming to court with a cap, with a hat. In some societies, the hat is part of the dress. Like among the cattle keepers, they just come to court with a... So I think the magistrate had woken up on the wrong side of the bed, and the hat offended him. So sent him to jail for contempt of court. So they really need mentorship. So now that you are here, I now request you to make real that pledge, so that the Uganda Judicial Officers Association can get their van. It will also make me look powerful. Now they know. They'll now know that our minister, when he pledges something for us, it really comes. That one is small enough for me. The other things the Chief Justice can fight for. But this one, I think we can do it. I do believe that the choice of the judiciary is from a good catchment area. As usual, we hope that the majority will continue coming from within the bench, because those are the people who really know the environment. They are the people who the rain has been beating. Now that the grass is greener here, those who had been grazing very far, of course, are approaching. But we think still the judiciary should continue having the majority of those who are recruited, followed by the bar, the lawyers who serve the courts, and then we are next, the ministries, departments, and the agencies. Now we have people coming from Bank of Uganda, Revenue Authority, and so on. And then the academia. We also need those who are coming from academia. They can enrich the judiciary. And we have professors who are now on the bench. That's a good thing. And finally, the diaspora. How would we have gotten Justice Ogola if we had not thought about the diaspora, because he was away working for the IMF? So that balance, to me, our guest of honor, is very good, because it allows for cross-pollination. Those who have been on the streets banging tables, and those who have been on the bench, those who have been in the government offices, those who have been hiding in the Highbury Tower. That mix is very, very important for that. Lastly is some of the realities in our society. Yesterday we talked about mental health briefly during the judges' conference. Our chief guest, many of the people who are brought before court are actually sick. It is Justice Chibita who said all of us are a bit mad. It is a question of the degree. I think that is highly defamatory because he must be put to strict proof of that. But how do we protect those who are mentally ill, particularly in cases of estates? You are very rich, then you have mental illness. Then you are subjected to a lot of abuse by those who claim to understand your affairs better than you. I think we should even expand the debate, not just to be about mental illness, but even when you are an invalid, for instance, you are either having dementia, whether Parkinson's disease, any of these illnesses that are debilitating and they affect your judgment. All of you know about the disputes in one of the famous families where I think somebody is incapable of making decisions and the matter is dragging on and on and on. I understand the estate is being gutted and so on. So this is again where the judiciary should step in to declare what the law should be. If tomorrow I have forgotten everything, my head is empty, I'm on a wheelchair, I can't talk, I have to be fed, and then those who are part of my family are selling my property and so on, and how can the judiciary protect me? So you have given us homework. I think it is also our duty to give you homework that there are other frontiers where the judiciary needs to go to ensure justice. You have done many things, like the recent one, and I'm glad the Office of the Attorney General came as and admitted. We are used to licking our wounds whenever we are injured in court. We always heal and we come back. So I hope that mentally ill people and those who suffer from debilitating conditions will also be protected by the judiciary, because this other case, I understand they have now gone to appeal to the president. Why should they go to the president? The president has enough problems, Congo, M23, and so on. He's a busy man. Let the judiciary do its job. Once again, let me thank the judiciary for this curtain raiser event. Let me congratulate the members of the bar, particularly the president, our president. I'm, by the way, a member of the Uganda Law Society since 1994. We had had threats that you were not going to come. You don't know how happy I was to see you. And I thank you for leading the troops here. These disagreements are healthy. And for me, my only disagreement with you is that you never went to Namilyango, you went to Kisubi. But that is a rivalry which is historical. So we thank you most sincerely. The bar is the voice of the population. If you hadn't come, we would have missed a lot, and this occasion would have proceeded with a huge discount on it. So, as usual, it is my duty to invite the next speaker, who, by the way, across the Nile is also my big brother and an elder. So, in matters of protocol, I'll never catch up with him, even if I became president. He will still be summoning me. That one, there is no negotiation over it. My Lord, the Honorable the Chief Justice, it's now my honor to invite you to address us, my Lord.
The Right Honorable Prime Minister of the Republic of Uganda, representing His Excellency the President of the Republic, my Lord the Honorable Deputy Chief Justice, Your Grace, the Archbishop of Church of Uganda, and your colleague, member of the clergy, the Honorable Minister of Justice and Constitutional Affairs, the Deputy Attorney General, my Lord the Principal Judge, my Lords, the Honorable Justices and Judges of our Courts of Judicature, Your Excellencies, the Ambassadors, High Commissioners, and other members of the Diplomatic Corps here present, the various heads of government, departments, agencies, and statutory bodies, the Permanent Secretary of the Judiciary and other Permanent Secretaries here present, the Deputy Commissioner, Prisons, the representative of the IGP, Your Worships, the registrars and magistrates, the President of the Uganda Law Society, and distinguished members of the legal bar, the presidents of the various universities, Law Students Association, more specifically Gulu University, Cavendish, Kampala International, Uganda Pentecostal, and Bishop Stuart Universities, distinguished ladies and gentlemen in your various capacities, Right Honorable Prime Minister, we welcome you here with both hands, and we ask you to convey to His Excellency the President our appreciation for his enormous contribution to the judiciary transformation agenda, which has been the hallmark of my administration. When I came to office, the judiciary budget was a paltry sum, 198 billion. Somebody needs to do some simultaneous equation for me and tell me what percentage of the budget it is, or it used to be. I need to know. And what percentage of the GDP that one was. As I speak now, the President of Uganda Law Society, in his typical way, is invading my space and saying he is embarrassed He has not been asked to come and speak. I'm not in charge of protocol, so I don't have an answer for you, but I will certainly address you in my speech. Thank you. As I speak now, the budget of the judiciary has virtually quadrupled in the close to 5 years I am in office. When we talk of the pursuit of our transformation agenda, when we speak of the many visible changes, when we speak of the number of judicial officers having catapulted, say in the case of the High Court, from 50-something to close to 100, magistrates from 100 to 300 and something, registrars from less than 10 to close to 100, it is because His Excellency the President has understood the need to invest taxpayers' money in the judiciary so that we can play our part as one of the 3 arms of government. So please kindly convey our appreciation to His Excellency the President. I would have wanted to say this to him, but he's not been able to come, so I'm now conveying it through your good self. 2024, which is the year under review, a number of things happened in the judiciary. This booklet runs into over 30 pages. I'm not reading it verbatim. I'll just pick each one of you interested in knowing what transpired in the year 2024. You'll get access, either the hard copy or the soft copy. This will be availed to everyone who is interested to know the state of affairs that obtained in the judiciary in the year under review. We performed better than the year 2023. In the year 2024, there was slight increase, there was slight improvement. Again, it is attributable to the increase in numbers, more use of IT, more training, greater discipline, and a host of other things. So of the cases that were before us, we were able to dispose of 59.6. When I was in primary school, we wouldn't say 59.6. We would take it to the nearest whole number, and this would be 60. So we disposed of 60% of the cases that were before us. Given the challenges we have, I think this is a recognizable contribution in case disposal endeavor. We've given the details, you'll find it in this booklet. The details is broken down, what each court did, and so on and so forth. Uganda is now known for the plea bargain intervention in criminal justice disposal. It's taken root. Uganda is now being benchmarked by regional jurisdictions, by the African jurisdiction, on how we've done it. and how we continue to do it, how the various jurisdictions can benefit from what Uganda has done. In 2024, 2,865 inmates enrolled under the plea bargain scheme. A total of 2,672 cases were disposed of, leaving 193 cases only pending. 177 inmates opted out of the scheme, so the success rate of the plea bargain in the year under consideration was 87%. The importance of the plea bargain, I can say, is threefold. One, an accused person who pleads guilty has exhibited contrition. To say guilty is to say sorry. I recognize that I've done wrong. And then when you bargain, you now seek forgiveness. That's really what the bargain is all about, the sentence and so on and so forth. And then it brings real closure to the criminal dispute. The aggrieved parties go back knowing, and they are really involved in the process, they go back knowing that real justice has been done. It's not between the state and the accused person. It involves the aggrieved persons. And for the Ugandan judiciary to dispose of 2,800 criminal cases through the usual means, calling evidence, listening to all of them. At one time, before we went digital, the judge was also the secretary, had to take notes in the long hand. To complete 2,865 criminal cases would take years. This was done in 1 year. Then the cost of conducting criminal cases through the plea bargain is a huge relief to the taxpayer. When we handled, in 5 years, we handled 35,000 cases under plea bargain. It cost us 10 billion to do that. If we had done it through the ordinary sessions, full trial, it would have cost us 35 billion and more than 10 years to complete those. A lot more than 10 years. So we had a saving of 25 billion Uganda shillings because of adopting the plea bargain mode of criminal justice delivery. We've given a summary, we've given a breakdown of how this was conducted in the year under review. Then for the small claims procedure courts, we have expanded. These are cases which are not more than 10 million claims each. Currently, the small claims procedure is rolled out to 195 courts across the country. The expansion of the small claims procedure courts and the growing number of cases registered reflects a largely user-friendly and demand-driven initiative. The small claims courts recorded a steady growth in disposal at both claim and demand notice levels over the 3 years under review, as indicated in the table below. You'll have time to go through this table. Then there is the mediation program for the year 2024. A number of activities which I've spoken about before happened in the year 2024. So one can say the year 2024 has been pivotal for the robust introduction of ADR. Out of 3,391 mediation causes, out of the 5,708 mediation causes registered, we completed 3,391. Out of the 3,391 causes which were disposed of, 2,028 were fully settled. 127 were partly settled. 1,197 mediations failed. 2 mediation cases were closed due to non-attendance of the parties, and 37 were withdrawn, and 14 were closed due to mediation time lapse. This translates into a success rate of 59.8%. Let me also say, the mediation were not only with regard to trial cases. It went up to appellate court. The Court of Appeal was able to resolve some matters through mediation. This is a very good point about the importance and success of mediation. Enhancement and advancement of the human resources. Our human resources have been expanding through new recruitment, incremental and replacement basis, and then regularization in the service. We had new appointments and promotions. The list is given. The staffing levels as of 21st January this year, 2025, records the judiciary having a total of 689 judicial officers, being 100 justices and judges and 589 magistrates. I set out the record. The Supreme Court has an approved structure of 11 justices. 10 have been filled. There's 1 vacancy. I'm made to understand 1 has been nominated to fill that 1 vacancy. We are very happy to hear this. Justices of the Court of Appeal, which serves also as the Constitutional Court, the approved structure is 35. 13 places have been filled. I'm made to understand there are new nominations to fill the vacancies. The High Court judges, the approved structure is 151. We were 77 as of 1st of January this year, but I'm glad to report 21 nominees for High Court have been determined, and the matter lies with the Speaker of Parliament. The lower bench, we have 1 Chief Registrar, so there's no vacancy as of now. There might be 1 in the next few days. we have 11 registrars out of 12, one vacancy. We have 42 deputy registrars out of 80. We have 24 assistant registrars out of 40. We have 100 chief magistrates out of 160. I also gave, for senior principal magistrates, we have 11 where we need 40. For principal magistrates grade 1, we have 23 where we need 50. For magistrate grade 1, we have 332 where we need 514. Magistrate grade 2 is being phased out. So the total we have the approved judicial structure would be 1,164. Only 50%, 58% has been filled, leaving a vacancy of 489. From the table, which you will be able to read, it can be seen that in spite of the vigorous efforts and recruiting staff, the current judicial officers only constitute 51% in the upper bench and 60% in the lower bench out of the approved structure. This is partly because of the retirement and death of some judicial officers over time, and the fact that others are promoted from one rank to another, which in effect makes no addition to the staffing level. It is therefore desirable that in the short term we should recruit more staff to about 80% of the staff structure to realize the desired impact. Capacity building of the judicial officers. The judiciary has continued to prioritize capacity building of its staff through training of judicial officers in relevant fields and emerging trends that are critical to the administration of justice. The trainings conducted include: 1. Induction of all newly recruited justices, judges, registrars, and magistrates. 2. Training of judicial officers in adjudication of communication-related offenses, sexual and gender-based violence offenses, climate change and environmental offenses, ICT and tax system in Uganda, trafficking in persons, cybercrime, child psychology and development, among others. Retirement. I give a table of the number of judicial officers who have retired, and we hosted those who have retired and remembered the good job they have done. Now, many of you should be able to know, and for those of you who do not, I would like to announce that the Honorable Deputy Chief Justice will be retiring in April this year, after an illustrious over 40 years of judicial service to his country. I take this opportunity to heartily appreciate my Lord the Honorable Richard Butera, the Deputy Chief Justice, whom I have had the privilege to work with. I knew him in 1982 when I was a second-year law student. For some of you who were born yesterday and you have the courage to abuse some of us, we've been around for a much longer time. He was a tutorial assistant and he assisted us in commercial law too, together with the now retired principal judge Yorokamo Bamwine, who helped us to understand the law of torts. I admire Justice Richard Butera for one thing, among many, but the one which I think people need to know. When you head an institution like the one I am doing, and you have your immediate subordinate, your deputy, in the persona of Justice Richard Butera, you are a very fortunate person. You know, God creates us differently. I always say without any fear that for me, if you step on my foot, you better move your foot away because I will step on your foot too. That's how I've been created, and there's no pretense about it. But also the good thing is that after you've stepped on my foot and I've stepped on yours, when we meet, the stepping on the foot is no longer in my mind. We now meet and life continues now positively. When things are tense, when the climate is not favorable, when there is belligerence abounding, Justice Richard Butera has always been a cooling presence. Innumerable times I have called him in the middle of the night, my Lord, for some reason I'm not able to do this, please step in. And in the morning he's there to do it. No excuse. And he goes and represents the judiciary as if he was prepared for 1 month. He's not given to any pretense. I don't know, my Lord, if you have any ambition in life, I don't know, except to do good. I don't know if that is an ambition, that is an attribute. But it's one person you can always sleep and you know he has a knife in his hand, he will not stab you. Many people are good at stabbing their colleagues on the back. Justice Butera will never stab you from behind or from in front. He will always give you very good counsel, very brotherly. He understands what fraternity is about. He understands what it means to be a family. We in the top management family, we benefited enormously from his wise counsel, from his cool temperament, and so. So my Lord, we will miss you, but we know you'll always be perpetually with us. He is the person who headed the committee for the building of alternative dispute resolution in the judiciary of Uganda. I gave him the task, he took it up. Where we are is because I chose the right person, a person whose it is in his genes to mediate, not to pursue adversarial means of dispute resolution. It is in his nature that things are done by sitting down, by talking, by listening to the other side. I know you'll still be with us. I'll say more the day we say thank you to you formally, but I thought I should seize this opportunity to speak a little about your contribution to your country. We lost some members of our staff, I've recorded that. As you now know, and for those of you who had ever been here before last year and only came here now, the scenery here is different. We have the towering twin towers which has changed the landscape of Kampala, which has changed what used to be known as the city square. It's a home befitting of one of the three arms of government. We were able to do it, and the biggest lesson from our ability to do it, and I want to thank my PS because he was the head of the foot soldiers in doing this. Mine was to say, I will not hear of any rumor, I will not hear of any scandal about money in the construction of the Twin Towers because people will go to jail. He conveyed this information to everybody, I think even to the contractors, I don't know. I think he conveyed that. The Chief Justice told me this when he was smiling, and that's when he's most dangerous, when he says something, when he's smiling. In the end, I don't know if it has happened anywhere in this country before, we made a savings of 8 billion shillings. In all other ventures, governmental construction, by the time we completed, they would have varied. It is called variation. I'm not an engineer. You vary the bills of quantities. They would have varied it 3 times. The cost would have gone up by 5 or 10 times. But for us, because we know this is the taxpayers' money, it is paid through sweat, and we owe it to our country, we owe it to our people. And this is the judiciary. You cannot associate the judiciary with corruption, you cannot associate the judiciary with thieving. And then where will you have the high moral ground to try a thief if you are indulged in thieving? So we did this. Now we are in our home, and I'm glad that the President has asked various leaders of this country to come and benchmark how you can do it. Right, Honorable Prime Minister, your various departments can do what we did in the judiciary. It's not rocket science. It's just putting your foot down. It's just realizing that this is your own money. If it is squandered, even if it is donor money, the donor money is coming from some taxpayer in the donor country. Somebody has had to part with money so that it comes here. So we can, what we've done in the judiciary can be done everywhere else in this country, and we remain a proud people that when tasked with the responsibility to perform, we did without any stain. We've completed construction of various high courts, Mukono, justice centers, Zimbabwe, Buwejo, and other places. We are constructing 12 court buildings in various places. We are renovating court buildings in various places. We found, again, my PS is a down-to-earth person. He moved to various up-country courts. In one instance, he went to a building and he began rubbing his finger, I think it was his forefinger, index finger, on the wall, and what came out was sand. You're just rubbing on the wall, and what comes out in your hand? Sand. Meaning there was no cement to hold it together. The current construction that we are doing in the judiciary, and I say this so that our partners should hear, they can verify, we mean business. You win a contract in the judiciary today for any infrastructure project in the judiciary, you know you'll run into problems if you play around. So you can take a tour to any of the structures, come to the PS, they'll give you an inventory of structures that have been put up during our tenure. Take your own engineers, go and find out how these structures are. So I'm happy to report that the taxpayers' money which has been used for putting up a building today will not require taxpayers' money to work on this building 5 years, 10 years to replace those buildings, as was the case before. Because the buildings are satisfactory and they are done professionally. Now, there are reforms in the legal and regulatory framework. A number of interventions have been registered in the legal, regulatory framework and procedural rules as follows. The Judicature Amendment Act number 3 of 2024. Parliament passed the Judicature Amendment Act 2024, which increased the number of justices of appeal from 15 to 35, including the Deputy Chief Justice. This has greatly boosted the court, with hopes to open branches at Mbarara and Gulu and then extending it to the other places. We hope to open Mbarara and Gulu this year to reduce the distance covered by court users to access the Court of Appeal services. The recruitment of more justices was commenced last year. I have heard official rumors that names have been sent to the Speaker of Parliament. It's a sizable number of judicial officer nominees. When the process is concluded and they are sworn in, it will greatly impact service delivery by the Ugandan judiciary. There is the Magistrates' Courts, in bracket Magistrates' Courts and Magisterial Areas, close bracket Instrument 2024. In furtherance of our dream of bringing courts nearer to the people, countrywide consultations were carried out, resulting in the enactment of the Magistrate Courts and Magisterial Areas Instrument 2024. The instrument was gazetted on the 23rd of February last year as statutory instrument number 11 of 24. Under this instrument, every district in this country has a chief magistrate. In other words, every district is a magisterial area. But we'll have a chief magistrate's court, and every county constituency will have a magistrate grade 1 court. We have already established more courts, and we are looking for funds and more manpower to operationalize more courts across the country. 3, the judicature, in bracket electronic filing service and virtual proceedings, close bracket rules 2024. The Rules Committee considered and passed the judicature electronic filing service and virtual proceedings rules 2024, which are pending gazetting. These rules will enhance the use of ICT innovations within the judiciary and will therefore enhance case management and performance of judicial officers. The rules provide, among others, for the following e-services. 1, use of technology in court processes. 2, electronic register and electronic filing. 3, electronic service and exchange of documents. 4, virtual proceedings and virtual hearing procedure. 5, e-signing and sealing of judgments and court records. 6, e-auctioning, e meaning electronic. 7, digitization of case files filed physically. 8, electronic archiving and transfer of case files. Number 6, automation of courts. The Electronic Court Case Management Information System, ECMIS, is currently being successfully implemented in 13 court stations, which are the Supreme Court, the Court of Appeal, 6 High Court divisions, Luwero High Court, 3 Chief Magistrates Court, namely Mengo, Buganda Road, and Standards, Utilities and Wildlife, and LDC Magistrate Grade 1 Court. The implementation of ECMIS has given rise to the following. 1. Rollout of ECMIS has increased the case filing rate to 20.6% in the courts operating ECMIS. The average case completion rate has also increased at a rate of 17.5% in the courts operating ECMIS. ECMIS has increased non-tax revenue collection from 5 billion to 9.2 billion. B. Video conferencing systems. The judiciary has continued to enhance the capacity of courts to handle cases online through the installation of video conferencing facilities. A total of 17 video conferencing systems are installed in the courts as follows. 1. Supreme Court, Court of Appeal, High Court at Kampala, Commercial and Criminal Division, 11 High Court circuits, namely Mbarara, Arua, Masindi, Masaka, Jinja, Soroti, Lira, Fort Portal, Kabale, Mubende, and Bale. Buganda Road Chief Magistrates Court. Internet coverage. To improve automation of courts, the judiciary embarked on extension provision of internet to the courts. By the end of the year 2024, the coverage of internet in the courts across the country stood at 46%. The other events that occurred in the year 2024, we had our annual Judges Conference. We conducted a tailor-made training on ADR and on the 4th of March 2024, a section of members of the judiciary family who had completed this training graduated with a master's degree in dispute resolution and a certificate in international commercial arbitration of the Pepperdine University, United States of America. The graduation ceremony was conducted at the judiciary headquarters, and the 11 graduates, who included the Honorable Chief Justice of Uganda, where the Chief Justice himself is still the Chief Justice, not another one, the Honorable Richard Butera, Deputy Chief Justice, Honorable Norbert Mao, Minister of Justice and Constitutional Affairs, Honorable Justice Mike Chibita, Justice of the Supreme Court, Honorable Justice Geoffrey Kiriavire, Justice of the Court of Appeal, Honorable Justice Paul Wolimbwa Gadenya, Judge of the Criminal Division, Honorable Justice Richard Wabwire Wejuli, Judge of the International Crimes Division, Mr. Francis Atoke, then Solicitor General, Ms. Rachel Odoi Musoke, Senior Technical Advisor, JELOS, Professor Andrew Kaoka, Technical Advisor, Judiciary, Francis Gemara, Senior Counsel. Following this, we did a number of things. I've already told you I appointed the Honorable Justice Richard Butera, Deputy Chief Justice, to head the committee on the promotion, establishment and promotion of alternative dispute resolution mechanism in the Ugandan judiciary. The judiciary of Uganda held an ADR week from 5th of August 24 to 9th of the same month, during which the courts dedicated time to educate the court users and encouraged them to consider alternative modes of settling their disputes. This was part of the ADR series that started with the plea bargaining conference held in June last year, and the plea bargaining camp that was held in Ugandan prisons also in June. A total of 10 courts participated in the settlement week. These were the Court of Appeal, Land Division, Civil Division, Family Division, Commercial Court, Mukono High Court, Masaka High Court, Gulu High Court, Makindye Chief Magistrates Court, and Mengo Chief Magistrates Court. The targeted output of the settlement week was 200 cases. This target was surpassed. A total of 847 cases were cause listed, out of which 235 cases were successfully mediated. So we achieved more than 100%. You sit for an examination and you get more than 100%. I don't know if there is any grade better than A. So that's what we achieved. Maybe A triple plus. We've given the breakdown. We've given the breakdown. There is a table here on page 16. I was amazed by the remarkable settlements realized in just 1 week. 49 cases were concluded at the Court of Appeal. The Court of Appeal resolved appeals through mediation, through alternative dispute resolution. Maybe this is one of the most remarkable thing about ADR. 35 at Family Division, 31 at the Commercial Court, and 66 at the Makindye Chief Magistrates Court. This was a miraculous achievement. We undertake to conduct ADR weeks regularly for the benefit of our esteemed court users, justice seekers. The Family Justice Summit, under the auspices of the International Law Development Organization, IDLO, the Family Justice Summit was conducted on the 12th and 13th of August 2024, during which the various family justice stakeholders shared experiences and challenges. Honorable Justice Martha Koome, Chief Justice of Kenya, delivered a keynote speech in which she emphasized the need for expedition in handling family cases, because prolonged legal battles leave families in a state of anxiety and certainly increasing stress and hindering production. The Family Justice Summit was an eye-opener to the vast, unique challenges that family justice faces, which the judiciary is committed to resolve. The need for ADR interventions in family matters was highly echoed. Commissioning of the court-accredited mediators. Following a number of practical trainings on ADR, in May, in conjunction with the Pepperdine University, I commissioned the court-accredited mediators in an effort to implement the Alternative Justice System Strategy 2023. The one the Honorable Minister of Justice says is going before Cabinet now. The mediators were subsequently deployed in various courts where they are executing their work quite effectively. We break down the courts where they're operating. I've tabulated it here. And then we did regional trainings for court-accredited mediators. National Court Open Day. The judiciary organized the first ever National Court Open Day in April of last year to give opportunity to the court users and stakeholders to interact with the court administration and court staff of the various courts in Kampala. The following courts and departments erected exhibition stalls and interacted with the court users at close range. The Supreme Court, the Court of Appeal, all the 7 High Court divisions, the East African Court of Justice, the Inspectorate of Courts, the Judicial Training Institute, the Industrial Court, and ECMIS as a program. Among the other key participants were the Uganda Police Force, the Uganda Prison Service, the Office of the Director of Public Prosecutions, the Law Reform Commission, UNODC, and the Law Development Center. The feedback from the participants was quite useful to our future plans for the judiciary. Valuable information was shared, and a number of complaints were addressed instantly. We plan to have this arrangement on an annual basis, in addition to the other court open days organized by individual courts. I already mentioned to you, we put up these twin towers. The President commissioned it last year in April. I've already given you the story of the twin towers, what was done, and why it stands out as an example of how and why it is possible even for government to do business without soiling its hands. In these two structures, it is a state-of-the-art court building. We have health and wellness centers which are fully operational, with a state-of-the-art gym, massage, sauna, and steam bath available all week long. Honorable Minister, you can come to the PS and he'll be giving you a card so that you walk in and enjoy all these things. Where you don't suffer the other Lugambo, you come here and the attendants are highly trained and experienced in the job. I invite your lordships to join us and reap the benefits of these important facilities. Right Honorable Prime Minister, again extend our appreciation to His Excellency the President of Uganda, because when the idea of putting up these twin towers came up, he said the Ugandan taxpayers must put up this building. So every coin that went into putting up these two structures was from our URA collected funds. It did not come from anywhere else. Benchmarking visits by sister judiciaries. The Ugandan judiciary has grown. We've really improved in many areas. We are now a destination point for other jurisdictions. Kenya, Malawi, Zambia, and others. Others are still planning to come. Coming to know, how have you done it? How have you been able to do this? So we intend to continue like this. For example, in May this year, we are hosting an international conference on commercial justice, which brings together jurisdiction in the African continent, here in Kampala. Again, this is evidence of the confidence the world has in the Ugandan judiciary because of what we've done in the recent past, and we continue to do. We have operationalized various judiciary committees, a whole range, 10 of them: Planning, Development and Finance Committee, Case Management Committee, Law Reform Committee, Anti-Sexual Harassment Committee, Performance Management and Awards Committee, Disciplinary Committee, Information Committee, Communications Technology and Documentation Committee, Integrity Committee, Human Capital Development, Gender and Equity Mainstreaming Committee, and Audit Committee. The Audit Committee is chaired by a retired judge. We thought it would be better that way than having it as an internal matter. So with these committees effective up and running around, it can only add to the performance, the better performance of the judiciary. The commemoration of the Chief Justice Benedicto Kiwanuka, this is an annual event which we know will continue to do it in memoriam. At the last function, the retired Deputy Chief Justice Seth Manyindo and retired Principal Judge James Ogola, both of whom, after retiring from service of the judiciary, became chairs of the Judicial Service Commission, they were awarded the Benedicto Kiwanuka Rule of Law Award 2024 for their outstanding contribution to the administration of justice and rule of law in Uganda. Uganda is a member of the Southern and Eastern African Chief Justice Forum. We held a conference here last year. We also conducted benchmarking trip to Tanzania. We held other events which you'll see when you look at this document. Challenges and bottlenecks. In spite of the numerous achievements registered during the year 2024, the judiciary has grappled with the following impediments. 1. Inability to raise quorum at the Supreme Court. Right Honorable Prime Minister, we had hoped that Parliament would enhance the number of members of the Supreme Court to a minimum of 15. Most unfortunately, this was not done. We remain at 11 for the structure, but we have been at 10, but effectively 9. This is not easy. I need to explain to you as a lay person a sizable number of the people who are in the Supreme Court, including the Chief Justice, were members of the Court of Appeal. Now the Supreme Court hears matters or hears appeals from the Court of Appeal. You will almost invariably find that when a matter comes up and you are supposed to constitute a panel, we call it quorum, the people who should be sitting on this have handled the matter in the Court of Appeal. And then you only need to be less by one person and you cannot sit. This is very frustrating, very, very frustrating. So we think when an opportunity arises, we ask the executive, we ask Parliament to reconsider, at least raise the structure of the Supreme Court to 15. The justices are there. You try to put up a team, and the law says if you handled it before in the other court, then naturally your mind is biased, which is a natural thing. So my appeal is, let's add 4 more people in the structure of the Supreme Court. But also extend our appreciation to His Excellency the President for nominating 1 more person to the Supreme Court, so that we have, by this structure which I'm complaining about, we can have a full house. less one, for reasons which I'm not going into now. In capacity of sister agencies, we made massive recruitments of magistrates, members of the lower bench, massive. But the Directorate of Public Prosecution could not cope up. At one point, I had to forfeit my own funding to support the Directorate of Public Prosecution to recruit staff. So there are many of our courts without prosecutors. They only handle civil matters. Criminal cases are had 40 kilometers away, 60 kilometers away, and it is not easy for litigants. So again, I make the plea for the Directorate of Public Prosecution, for the Office of the Attorney General. You can't give me a V8. I hope I'm saying it right. I'm not an expert in types of vehicles. To take me to Moroto, it will not break down on the way, but you've given me fuel which stops at Katakwi. Now you're not helping me to reach Moroto. I will drive from here very happy. I reach Katakwi, I am done, and there is no fuel station. The last fuel station is in Iganga. So we've done nothing really. So I'm asking that let us have commensurate support. The support which is being given to the judiciary should be given to the chambers of the Attorney General, should be given to the Directorate of Public Prosecution, so that we have effective service to the Ugandan people who seek justice. When I made the case for our budget here in 2021, I had just been made Chief Justice. That was my maiden New Year presentation, New Law Year presentation. I asked the President why the budget for Parliament was 800 billion and the one of the judiciary was 198. What was it that Parliament was doing that the judiciary does not do to deserve 800 billion? He gave his word that we would raise the judiciary budget to match that of Parliament. We appreciate COVID-19 set in, and according to the President, in 3 years we would have achieved this. We understand we are reasonable people. Very reasonable people, and that's why we are judges, because we are reasonable. But that notwithstanding, we still ask that there must be meaningful, incremental alteration in our budget annually, so that I am retiring in 1 year. I want to hear when I'm still alive. I intend to stay alive for quite some time. I really want to hear that the judiciary budget matches that of Parliament. I would really, really be very happy. I would really, I'll write a piece somewhere and thank the executive and thank Parliament for doing this. Because whatever we have done differently from our predecessors is because our basket is more full than theirs. When theirs was at the bottom, at least ours is midway. I mean midway in the bucket, in the basket. That's why we've made a difference. And I would love to know that my successors even makes bigger and better difference than I tried to do when their budget is basket full to the brim. The low wages of administrative and support staff. We've made the case that there's need to revisit the wages of the non-judicial officers. The judicial officers are fairly taken care of. Of course, not enough, but fair. It's fairer than either two. We think this should be matched by attending to the non-judicial officers The judicial officers alone will not work. The clerks, the secretaries, and the other persons who are in administration. This area needs to be revisited. 5. Right Honorable Prime Minister, there is this cancer. I do not know where it is coming from. I do not know why it is happening now. It is a trend, very dangerous trend, where people relish, people find pride, people think they have greatness in attacking instead of criticizing judicial officers. Name them and say unthinkable, unprintable, the type of thing you will not say near your sister, near your mother, but they will say it openly. I cannot repeat those words. They are in the public domain. We, as the judiciary of Uganda, we've exercised self-restraint because of the oath we've taken. We've taken oath to render justice without fear. Even when they insult us, that should not intimidate us. To render justice without favor. Without any affection. And without bearing any ill will against those who offend us, even when they offend us at a personal level. Most unfortunately, the institution that should protect the judiciary most is the one leading in this ungodly assault on judicial officers. The world over, it is the law societies of the various jurisdictions who are always up in arms to defend the judiciary, to defend the courts of the respective countries. Because, first and foremost, a member of the law society is first and foremost responsible to the courts of the land. The moment you're enrolled as an advocate, what has been accorded you is the status of an officer of that court, the courts of judicature of that country. And by reason of that, you can represent justice seekers in court. By reason of that, you can practice and help develop your country. Now, when the leadership of a law society is the one taking the lead to drag judicial officers into the mud, is the one, just because a decision has been made which you're not happy with, and then when a decision is made which you think favors you, you're all over the place thinking the decision was made for you. Judges do not make decisions for any person. They make decisions in accordance with their understanding of the law. If the law favors you, it is the law that has favored you, not the judge. If the law does not favor you, it is not the judge who has not favored you, it is the law that has not favored you. Indeed, many times, including me, we make decisions which are wrong. When we look at it later, we say, oh, how did I miss this aspect? It is part of the responsibility. And that's why the law provides for a higher court to mark my script, to tell me, and they normally use very flowery language when they are rebuking you, with the greatest of respect, when they are tearing your judgment to pieces. I would want, in the few months that I am at the helm of this institution, to hear that the leadership of the Uganda Law Society, the members of the Uganda Law Societies, justice seekers, know and understand the difference between criticism and abuse, the difference between constructive criticism and vulgar, uncouth, primitive assault on members of the judiciary. We can only restrain ourselves for a while. But if the judiciary, if we sit down as judges and make a decision, there's only one loser. It is the Uganda Law Society that would lose. If we say we are not giving audience to any member of the Uganda Law Society, you'll be out of business. But we believe there are still reasonable people even in the Uganda Law Society. We believe even Saulo can become Paulo. We won't adopt the principle that even me, I will not throw the first stone. We have all wronged one another somewhere in our lives. My appeal as an elder, somebody who became a lawyer before many of you who are abusing us were born, I think nobody even thought you would be born anyway. Search your individual souls. Have the courage to own up for the wrongs you've committed. It is possible, easily possible, and we are willing that we begin on a new slate, clean slate. But that comes about if you own up and you offer apology. If you don't apologize to Justice Owiny-Dollo, it doesn't matter. But please apologize to Justice Musa Sekana. Because what you said about Justice Musa Sekana, I mean, nobody in their right senses, only somebody who deserves to be taken to Botabika to have the head examined could say those things. I hope this is the last time I speak about it. I hope this is the last time I speak about it. Because next time we will respond. And if we do respond in like manner, there's only one loser. The judiciary of Uganda will not lose. Individuals in the Uganda Law Society will lose. I hope it doesn't come to that. The ball is right at your goalpost. You either take it or you allow it to go to your net. That is my challenge. I think that is the gravest thing that has happened during my tenure as Chief Justice of Uganda. It has never happened before. And many times I ask, is it because I am the Chief Justice? So I'm asking the leadership of the Uganda Law Society. Many of us here, the Chief Justice is a member of Uganda Law Society. I was a member of the executive committee. Look at your record. I've never had anywhere in the world anybody being given a medal for abusing others. I've never had. Maybe it is, or entering the Guinness Book of Record for being foul-mouthed. So I hope this is the last time I speak about it, because I will not, again, I will take action. This is not a threat. I will take action. But I've left the door wide open, all the windows are open. Please, you know what you need to do. We can start on a clean slate. I give you my word. and we'll push everything behind, and we work to ensure that the rule of law prevails in this country. We need one another. I would be disappointed if members of the Uganda Law Society do not criticize us. Then I would ask the question, what are you doing? There's many, many ways, because when you are criticized, first of all, it means you're doing something. And in somebody's perception, you're doing it wrongly. Somebody's looking at what you're doing through a different lens. So we want you to criticize us. We want you to have constructive engagement with us. This is our country. It doesn't belong to me. The country does not belong to the president of Uganda, doesn't belong to the vice president, does not belong to the speaker, does not belong to the chief justice, except they as part of the Ugandan population. It belongs to all of us. This judiciary you need, you try to pull it down. Where will you run to? Where will you run to? You'll need it. You'll need it someday. I hope I have been loud and clear. I really hope I've been loud and clear. Now, our key priorities for the year 2025. Recruitment of more judicial officers. As I said, we've got word that His Excellency the President has acted. For us in our culture, when my sisters, please, I'm not using this in a negative sense. When the woman has conceived and you can see the belly is swelling, you celebrate already, but you celebrate quietly. So the fact that we know that there's something cooking in the pot, and the type of meal we enjoy most, you're already celebrating, Right Honorable, for what the President has done. We hope the process is expedited, the Speaker and her team finishes, so that we can have these appointments and we get to work. Enhancing case management and backlog reduction. Excuse me. I sent the Deputy Chief Justice recently, together with the Principal Judge, to Tanzania to benchmark how has Tanzania succeeded in taming this monster called case backlog. My lords, you look at that report, but one of the things is, one of the findings blames me. For me, Judge X say, I'm going for this, Dubai, I'm going where I endorse. I'm now going to change. You want to travel out of the country, I need to know how many judgments are pending. You must now tell me. That's what they do in Tanzania. It's no longer free fall. It's not going to be a free ride. So I'm going to implement this. Yeah. Yes, you want to travel. There are exceptional cases, but many of those travels which I've been very kind about, it will change. You want to travel, yes. How do you stand? So I throw it back at you. Enhancing the civil jurisdiction of magistrates' courts. Want to give more power to the magistrates. Some of these arguments about monetary jurisdiction can be really, really inexplicable. If it is a case about fraud, in conveyance of land, the law on fraud is clear. Whether it is 10 million shillings or it is 10 trillion shillings. You apply the same principle. So why do you think a magistrate cannot handle the issue of fraud regarding 500 million shillings? Should stop at 50 million. What sense is that? So these are some of the things we have revisited. The areas where we think our chief, in Kenya here, chief magistrates here, capital offenses, I think murder. Yeah, for us here, you know, it must be the High Court. So and this will give the High Court more appellate jurisdiction. The things they would hear as a court of first instance, now you'll hear on appeal. We think this will help in reducing backlog in okay. Yeah. That's right, Honorable Minister, that's okay. We intend to make alternative dispute resolution a more robust feature of our justice delivery. We actually want it to take over. In the United States, the last time I checked, was the largest economy in the world. Dispute resolution in the United States is largely through ADR, alternative dispute resolution, negotiations, mediations, conciliation, arbitration, these ones. For us, we're just introducing it. But the good thing is that it is in our African culture. All those factors in our African culture, we are going to formalize that so that ADR becomes the major form of dispute resolution. The alternative dispute resolution should be like 10% of all the disputes which are done here. That would be good for our people. That would give our people real justice. That would allow our people to access justice timely and more meaningfully. We will be constructing more courts. Right Honorable Prime Minister, fight for us to get the funds. We will increase the automation of courts, procurement of more transport equipment, provision of alternative sources of power to courts in remote areas. In some of those areas there's no hydro power electricity, procurement of furniture, and so on and so forth. In conclusion, Right Honorable Prime Minister, as I've observed before, the judiciary is not just a consumer. It is an engine of economic transformation and poverty eradication through effective regulation of economic activity, clarification and affirmation of rights, punishing of the enemies of progress, and strengthening of the laws, regulations, and institutional frameworks. The judiciary is a key player in providing an enabling environment to foster economic growth, promote wealth and job creation, as well as investment and competitiveness in the region. We therefore seek your usual support so that our work plan can be funded to enable us attain the milestones we have outlined above and elsewhere in our transformation endeavor. I wish to applaud Your Excellency and your Cabinet, the Parliament of Uganda, the Minister of Justice and Constitutional Affairs, and the Minister of Finance, Planning and Economic Development, and the National Planning Authority, among others, for your insurmountable support towards the realization of our transformation agenda. Allow me to extend further appreciation to the Judiciary top management, the Judiciary Council, the senior management and staff of the Judiciary who have tirelessly dedicated their time and energy to ensure that the Judiciary shines. I also wish to pay special tribute to our development partners and friends, and all of you who have contributed to our success in one way or the other. We heartily appreciate your support to the Judiciary and to the people of Uganda. Now, before I invite the Right Honorable Prime Minister to speak, let me say this. When I was delivering my speech, the President of Uganda Law Society, Advocate Isaac Ssemakadde, came here protesting that he has not been called to speak. I have two things to say. You can't come to somebody's home and say you must speak. I thought this is common knowledge. I mean, you don't have to, if you're an adult, you know somebody invites you, if he wants you to speak, he will tell you speak. You can't say you must speak. Yes. When you issue your executive orders, you don't need to come here to issue them. Two, I think only a fool, and I really mean it, somebody insults you, degrades you, dehumanizes you, and then he comes to your compound and say, it is business as usual. It is not. But you can make it business as usual. I've spoken about this. So I am the one who said the President of Uganda Law Society, called Isaac Ssemakadde, will not speak in the judiciary function. Nobody else. Until you make amends. Thank you. So I now take the singular honor to declare the new law year 2025 officially launched. And I also take this auspicious opportunity to invite you, Right Honorable Prime Minister, representing the Republic, the President of the Republic, to address the people here gathered.